Hello, and welcome to our first pre-recorded webinar hosted by the Wisconsin chapter of ASSE. The topic of this webinar is the OSHA Injury and Illness Record Keeping and Reporting Requirements, focusing on some of the new standards, new requirements, and some other advice. The speaker is myself, Todd Lusheen. I'm a professor at UW-Whitewater and the president-elect for the Wisconsin chapter. Some of the objectives is I want to show you where you can find information about the record keeping standard on the OSHA website, talk about the purpose of it, kind of going beyond what the compliance of it is, get into the more important considerations from 29 CFR 1904, which is the record keeping standard, some of the most recent changes, and I just did some Google searching to get some answers to the status of these changes, and then some tips to improve your record keeping practices. A little bit about me. Back in the 1990s, I was a compliance officer with Minnesota OSHA and actually spent time traveling around the state of Minnesota training people on how to fill out their 300 logs. But I've advanced from that point. While I was attending UW-Madison for graduate school, I worked part-time at the Wisconsin Department of Health and Family Services. And at that time, I was taking all kinds of statistics courses and research methods courses, and I was applying those new skills and knowledge to OSHA record keeping and analyzing the data. And I now teach this new technique, this analysis technique, in one of my courses, and I'm going to refer to it later. You see on the screen we have the OSHA website, and the front page, if you click on employers and then get down into the menu and click on record keeping requirements, this page will come up. And this page is the the injury and illness record keeping reporting requirements. You got the requirements on the top where you can find out, how does OSHA define first aid, what is a recordable, which I'm going to get into in a moment, the different types of records and forms that are kept, the new submission requirement, and the anti-retaliation requirement, and then also the new reporting when you have to call OSHA. So what's the purpose of the record keeping standard? Well, I have a little note here. It says pause to let the listener compose themselves after laughing from seeing this picture. Okay, well, it's actually not to bust you, but to get employers just to investigate accident reports and to try to identify causes and then try to resolve those, and at the end of the year review it. But what it's really about, if you do apply the data the way I did when I was working at the state and teach now in my classes, is that you're actually kind of applying a quality management approach. That if you're collecting data that is a status of how something's functioning, and if those measures show deviancy or variance from what is expected, then you analyze it to find its source and correct it, and leave systems in place and contingencies in place, redundancies in place to make system corrections so that you don't get the outcome you don't want. In other words, you're getting the quality you want. But I digress. Let's talk a little bit about the standard itself. Who's required to keep records? There's the exemption if you have 10 or fewer employees at any throughout the entire year. You don't have to keep it. That you don't have to keep the logs is really what it comes down to. If you want to see the partially exempt list of companies by NAICS, which is the North American Industrial Classification System, you can go to OSHA Fact Sheet 3744, which I actually do have a copy of, and you can find that on the OSHA website. This is it right here. Has the updates of OSHA's record keeping rule. It's got all the information here. I mean, this is kind of my presentation. Here's the new list of partially exempt industries. Going too fast for anybody to really read it. And then beneath this, they have the establishments newly required to keep records. There's a list here. So you can go to the OSHA website to acquire OSHA Facts 3744. Get back to the show. What is required? Well, there's under 1904B2 whether something is, did they experience something that would be considered an injury and illness, and is it work related, and is it a new case? And some people go, well, what's a new case? Well, if you get injured, the doctor may prescribe recovery at home or restricted duty or restricted movements. It's when the doctor has determined that you are back to your original health status and can return to work doing what you were assigned to do, that's considered a new starting point. So even if you re-injured yourself the same way you did prior, even if it was, the first day back, it would be considered a new case because you were deemed completely healthy. Supervisors typically do these investigations, and your company probably has either its own investigation form. OSHA has the Form 301. In Wisconsin, we also have a similar work comp form called the WKC 12E, and all that stuff is available online. Essentially, it's just capturing the information of the accident and then the results of the investigation. What was the cause? What was the nature? What was the body part, conditions, things like that. Just keep in mind that the person who is in charge of record keeping needs to be trained on how to determine if an incident is recordable and to keep the records updated. Don't just let someone to their own laurels and figure it out. That you should be training them if you're the safety professional. In January of every year, the 300 logs should need to be finalized. So you tabulate the columns. Hopefully you don't have anything in G because that's when you check when there's a fatality. But H, I, and J. H is days away. I is restricted transfer. J is other recordable. K and L are the days away and the restricted days, and then M is 1 through 4 or 1 through 6, excuse me, and that's where you check whether it's an illness or an injury or a type of illness. But you add those up and then you fill it in on the 300A form, which is the annual summary. That gets needs to be reviewed by an executive of the company. They sign off on it and date it, and then it's posted in a place where everybody can see it. So you may have a safety board, bulletin board in your workplace, or a break room, something that everybody sees, and you could even post it right next to the OSHA poster, which is another requirement, and that's posted February 1st through April 30th of every year. But there's going to be some new stuff coming up around the bend. What criteria do you consider whether something's recordable or not? Death, obviously, if it's work-related. Loss of consciousness, again, if it's work-related or in doing duties as assigned by the job. If the injury is work-related and it results in days away from work, or if the doctor has a physical or some form of restriction that they can't go back and do their job as originally assigned, or if there's medical treatment beyond first aid. Now, there's a big frequently asked questions portion in 29 CFR 1904, but first aid, that can kind of vary. The way I interpret it is if the treatment is something that goes along the lines of required medical training for a medical professional, then it's beyond first aid. But if it's something you could pick up in just your typical first aid class, you might take 2 to 4 to 8 hours at the Y. That's usually first aid. So simple bandages, gauze, butterfly strips, doing over-the-counter pain medication, ice, elevation, first aid. But when it would require some form of, like if you had to look something up online to treat somebody, but it should have been done by a physician probably, that would be beyond first aid. But you can take it as you want. This is a picture of the OSHA Form 301 in its paper version. It's got all kinds of information. Now, this information is going to be transferred to the 300. So this would be filled out by a supervisor typically, or whoever is designated to do the accident investigation. Have you focus over on the right under information of the case. So question 10 or item 10 is case number from the log. So this is something self-generated by the company. Do whatever you want, just so it connects itself to the 300 log, which is the row, the case. Date of injury, time, the event, and then 14, 15, 16, 17, and 18. Well, hopefully not 18, but 14 through 17 are really the what really happened. That's what you find in your investigation. That information is transferred to the Form 300. This is the 300 log. In its paper version, we recommend that you would keep it in electronic version like a Microsoft Excel or CVS or whatever software program you may have purchased to track your injury and illnesses. See A is case number, and that matches up to the 301. And as I'd stated before, you look over, you got column G for death, H for days away, I for job transfer restriction, and J for other recordable. I had mentioned that before. What I personally, professionally do not like about this approach is column F. Column F is where you describe the injury and illness, parts of the body affected, and objects, substances that directly injured or made the person ill. So one column contains all the critical information about the accident. If you're going to do any sort of trending or analysis, each one of these pieces of information need its own column. So you can sort it, so you can standardize it, and I'm going to show you how I did that at the state. To really analyze the data, you need to separate out all the key variables. And unfortunately, this log does not do that. This is kind of a strange way to analyze it because the GHIJ, that could be one column with one particular entry. There's different ways, but I digress. Here's the 300A. This is the annual summary. As I had stated before, you've got the number of cases from columns G, H, I, and J. Hopefully there's nothing in G. H, I, and J, you probably have some stuff there. K and L are the days, and then M with 1 through 1, 2, 3, 4, 5, 6. You put those numbers in, fill out the company information, a little bit about the hours worked or number of employees you have, and then an executive from the company you designate has to read it through, sign it, date it, and then it's posted again February 1st through April 30th, and that's posted right at the bottom of the page. Some of the recent changes are the reporting. Prior to, I believe, January of 2016, if I'm not mistaken, I'm trying to see it on the screen, I don't see it. If you had a fatality or 3 or more people were hospitalized, which would be admitted to the hospital, then you had to call OSHA within 8 hours. But they've changed that now. It's still 8 hours for a fatality, but the sort of the secondary or second tier is now a single inpatient hospitalization or amputation or eye loss. You need to contact OSHA within 24 hours. And as you can see, I've got this screenshot. There are different options. You can call the nearest office by clicking on OSHA office and looking up your closest one. You can call the 24-hour OSHA hotline, which is this 800 number on the screen, or you can report it online. So you just have to accomplish one, you're reporting through one of these 3 approaches, or options, excuse me. Another change was the anti-retaliation, which is part of the submission, in that OSHA is kind of restate, even though whistleblower protections are under the OSHA Act 11C, they kind of beefed it up a little bit with this anti-retaliation protections. And one thing that a lot of people are taking, there's the incentive programs. You've probably heard about this, that when a compliance officer during the opening conference is talking to the employer and they find out that they have a safety incentive program, that compliance officer should be digging a little bit deeper to find out, is it set up in a way that would cause workers or promote workers, motivate workers to not report injuries so that they can achieve the incentive. Same thing here. They're going a little bit further, and that was with drug testing, that would a worker not report an injury or illness because they feared repercussions because of the drug testing, because so they're trying to protect themselves because you're either getting in trouble or fired, but they're not reporting the injury. And so now, there were people out there who interpret this as can't drug test anymore, and that's not what they were saying. It says right here that it only prohibits employers from using drug testing or the threat of drug testing as a form of retaliation against employees who report injuries or illnesses. So, and I've read several interpretations of this on some law office or law firm websites, and it basically states you can't just blanket it out, but if there is a serious suspicion that it would be an intoxication was a major part of the cause, then drug testing could be done. That was the interpretation I got from online. Now you can also look up OSHA brochure 3905, recommended practices. Got a copy of that too. It's in PDF. And it's right here. And so we got recommended practices. You didn't really get to see it as much. It's a little bit longer than the other one, but this is something you could acquire and read through and make sure that it should be more than one page. It's 12 pages, whatever it stopped on me. So that's something you can find as well. Again, that's 3905. You can find on the OSHA website. The big one is the electronic submission. So as of January 1st of this year, this thing came into fruition in that starting this year, establishments with 250 or more employees in industries covered by the record-keeping regulation must submit information from their 2016 Form 300A, which should be posted right now, by July 1st. These same employers will be required to submit information from all 2017 forms. So that's the 301, 300, and 300A by July 1st of 2018. And then in 2019 and thereafter, it'll be by March 2nd of the year. the submission requirements. Interesting because March has submission requirements for environmental uh, permits. Establishments with 20 to 249 employees in certain high risk industries must submit their 2016 Form 300 by July 1st of this year. And then in 2017, their 300A, and then beginning in 2019, the information is March 1st. So the smaller companies, the 200 to 249 that are certain high risk injuries, which I'm going to show in a second, are required to submit their 300A every year. If it's July 1st this year, July 1st next year, and then in 2019 they're on to be March 2nd. And it says on the bottom that the state plans must adopt these regulations as well. Now, OSHA's stance, which is kind of peculiar, is that they believe that by companies submitting the data, one, they can improve their target inspections, which is their national emphasis programs, based on what they receive. Two, they may actually post some of the data on their website, which I believe is some form of public shaming. And what they believe is that's going to motivate employers to be more safe. I don't agree with that, and I know that there were some lawsuits filed by some business groups, but I think they were thrown out, if I'm not mistaken, from what I had read, which is online. You can't trust everything online. That's what Abe Lincoln said in his meme. But so it looks like this is going to go through, and that's what I had just read, that it's probably going to go through. Of course, it's funny that we just had the anti-retaliation discussion, and then now this, you think this isn't going to, promote or motivate companies from underreporting to OSHA? I'm sorry. I just feel like I see a little bit of hypocrisy just in this one thing here on the anti-retaliation, and then this public shaming. I don't agree with it. So that's just my professional opinion. Don't take it for any more than that. Here's the companies that are the high risk industries that are required to submit the 300As this year, next year by July 1st, and the year after by March 2nd. You can see that this covers a lot of companies. And this is something you can also find on the website from that original page that I'd shown you. Now, what I'd like to talk a little bit about is how to improve your record keeping. Too many companies just treat it as just a pencil whipping exercise, but it doesn't need to be that. If you really want your safety program to improve, you want to show which areas need to be prioritized and focused on, it's something you can use. Now, you can download the OSHA forms in an Excel or CVS, I believe that's what it's called, format, and I've got the picture of the screen here, and that's where I got it. But there's a better way to do this. Now, I just want to give you a little background on what I mean, and that is that people naturally blame the worker. And so if you look at anybody's 300 logs, you look at some of the causes, and I've reviewed, I don't want to even estimate how many, that there's a tendency to blame the worker, that the worker wasn't paying attention, that they didn't follow the rules, that they knew better, and things like that. But that doesn't really fix anything. And you can go back to 1931 data that reported 88% of accidents are caused by unsafe acts, or a very recent, last year, a student of mine did a survey of the Upper Midwest, and the respondents reported that they believe that 60% of accidents are caused by unsafe acts. So there is a strong belief out there, and the reason for it is because of the natural human attribution biases, and that is the fundamental attribution error, actor-observer bias, and self-serving bias, that when we see someone get injured, we naturally believe that they fully made the decisions that led to it, that they full well knew the risk and they acted anyway and they got hurt. But if you look at human error in human factors research, there are so many things that go into a slip or lapse in the perceptual motor cycle that would lead someone to, incidentally expose themselves to risks, or they didn't perceive that the risk was as high as it was, or they just completely didn't perceive that there was anything there and were exposed, or they didn't have enough time to react, or they didn't have the experience to react, or the physiological ability to react. There's a lot of things that go into it, and I believe that an individual's or a person's perception of what needs to be done, their attitude toward it, and their actual behavior we can observe the physical environment are influenced by the work system around them. And I've got a picture of it beneath the person being shamed by being pointed at, that if we study we can observe the individual, but what's making them the way they are is the interaction of the environment, the task, the technology, and the organization. And if we suspend our natural tendencies to blame the worker and try to look upstream. And I think techniques such as 5Y and the fishbone diagram try to lead us that way, to look upstream, that the person did not intentionally get hurt. They didn't want to. It was an unfortunate outcome, and we need to correct the discrepancies in the system, the work system, that allowed that to occur. And you can also improve, how you look at your data too. I know we use incidence rates, but there are limitations to the incidence rates. I believe when you take an entire company's employee hours worked, not every hour work is the same risk. And I don't think calculating company-wide incidence rates actually reflects that. I think it dilutes what's really there. And I've actually analyzed, oh, this is unfortunate. I've analyzed different incidence rates within a company and found that they vary greatly. So here's some of the work I did when I was at the state. I broke things down and detailed, and this was actually after I had changed the way we did the accident investigations and trained on the systems approach, trying to remove blame from the worker. And we prioritized where to focus, and we saw some big improvements. So what I want to end this with is, before I show you a sample of what I created, that is to not get caught up in definitions and the standards and the taxonomy of it. Don't pencil whip it. This is an important thing to do, and if you take it serious, it can actually guide improvements in your safety program, and then you can actually track it. It's a quality management approach. And with anything that I was taught in grad school, 80% of the effort should go into the investigation, the setup, whereas only 20% is record keeping. But I know some people take it opposite, and they spend all the time trying to figure out whether it's recordable, what it's not, what's a first aid, what's not. And the thing is, the energy and time shouldn't be put into that. It should be put into the investigation, doing a fair, balanced investigation to find out what really happened. So right before I close, I'm going to show you what I built at the state. And so you see an OSHA 300 log here, and I don't know, can I zoom this in at all? Is that possible? Is that something we can do? Anyway, I got all the columns. What I did is I separated out F1, F2, and F3. That was one of the big things I had done. So I had causation here, body part, and result. Another thing I did is I created drop-down windows. Oh, it's not in this one, I guess. Oh, it should be here because I built it down below. But anyway, so I had built drop-down windows based on the state of Wisconsin work comp codes. So I've got the job codes here, the causation codes here, and the results code here. And I probably have a few things down below, and I've got some body parts. So that the people who are filling it out, it was just a click and drop down window. And I also built in I think I did something wrong here because it looks like something's going crazy. Otherwise I could have shown the drop down. There it is, see? And they could just choose it. And so I could give this to anybody who would want it, because then they could go in and enter in their own company's job codes, causation codes, whatever they use, and then enter in these numbers. And if these don't balance, then I've got some algorithms built in to check whether it's okay. Anything you put in the 300 log automatically gets put into the 300A, and then you can also analyze the top jobs depending over time. So I was always able to have an instantaneous or real-time analysis on my third tab, and so we can monitor, which jobs were deviating from expectation or really needed work. So that's really everything I wanted to cover and more, and some things didn't work, but that's with recorded videos, I guess. So if anybody has any questions, you can reach me at my work email. That's my office phone. You can try me there, but email is always best. And I believe we're also going to be hosting a question and answer during the regularly scheduled video time. So I really appreciate your time and coming to listen to this, and I'd really appreciate any contact or feedback you may have that would help us with future webinars. So thanks. Have a safe day.